Good morning, everyone. We're going to begin. I'm Dana Zimmerman with Fidelity National Title Group. In addition to being the claims liaison for the Fidelity New York Agency Department, I'm also the CLE and CE coordinator in New York State. And this morning, we're proud to offer our next combined CLE and CE program. Judy Lanahan, Senior Agency Counsel, will be presenting title considerations when insuring out of foreclosure. Before we begin, I will read the mandatory DFS announcement. First, display of approval documents. Provider, course, and instructor approval documents issued by the New York State Department of Financial Services are available for viewing by each attendee. These documents serve as documentation that your course is currently approved for credit. They also verify the approved number of credits, the license classes eligible to receive credit, and the course approval number you will need to renew your license. Second, attentiveness during class. During the instructional period, you may not conduct insurance or other business or read materials unrelated to the course. All electronic devices must be silenced. Texting is not permitted. Third, attendance policy. The New York State DFS requires attendance for 100% of the approved class hours. If you log in late, you may be denied credit for the course. If attendance requirements are not followed, instructors and providers may face disciplinary action, in which case credits may be jeopardized. Fourth, course completion documents. When you have successfully completed a course, you will be issued a course completion document showing the course approval number, eligible license classes, and the number of credits you have received for completing the class. Retain this certificate to use when renewing your license and in the event of a department audit as proof you took the course. Remember, you cannot use credits for any course more than one time per eligible license class. This morning, we are using web-based forms to verify your attendance and to collect evaluations. Anyone logged into the webinar will receive an email with access to both the attendance and evaluation forms within 10 minutes after the webinar ends. You will still need to indicate whether you are looking for CLE or CE credit, and if you would like CE credit, you must include your DFS license number or numbers if you have multiple entities. We will also continue to use program codes to verify attendance. At various times throughout the program, you will see 3 different program codes pop up on the screen, and Judy will also announce them. You must include all 3 program codes to receive CE or CLE credit, so please make a note of them on a piece of paper so that you can add them to the attendance form after the webinar. We ask that you please fill out the evaluation as we value your feedback. If anyone has any questions during the presentation, you can type under the Q&A section on the bottom right of the screen. Time permitting, we will answer the questions at the end of the webinar. Otherwise, Judy will get back to the questioner after the webinar. Now I'd like to introduce my colleague, Judy Lanahan, who will be presenting on title considerations when insuring out of foreclosure. Judy has over 25 years of experience in the title insurance industry. She came to Fidelity National Title Insurance Company in 2005 as agency counsel. She spent 3 years in Fidelity's claims department before returning to underwriting in July 2015. Judy, I turn the presentation over to you.
Thank you, Dana. Good morning, everyone. I'd like to talk about the foreclosure actions because in speaking to all the different agents, I can see that we're still continuing to insure foreclosures. They're not going away. And the foreclosure actions have actually become rather complex. The litigation itself can become complex, particularly if there are challenges to the action. And I wanted to provide some information today that would help you as agents be able to get through examining these foreclosure actions without being overwhelmed or confused as to what it is that we really need to focus on. So in the materials is the foreclosure takeoff sheet. I think many of you may already have this, and it's an important tool for your examiner. You can give this to your examiner, and this will enable the examiner to go down to the county clerk's office to look at the action and fill in the pertinent information, answer the questions. If the examiner gives you a completed takeoff sheet, you should have all of the information that you need to be able to assess the risk and make a decision about whether or not we can issue a policy out of the referee or an REO transaction. So if you're insuring out of a referee or an REO, for sure you're going to want to do a complete takeoff of the action. And the takeoff is not just a checklist. It's really, once the examiner fills out the information, it requires your reader to analyze the information and make decisions about the risk. So when we're issuing policies, this is an insurance company, and we're really always just assessing risk. And when we're dealing with a foreclosure action, because of the litigation, it's possible that there could be defects or things that weren't done exactly procedurally correct in the foreclosure action, and that may or may not cause us to feel that there is a risk. We could have a procedurally perfect action, but still have, and vice versa. So in looking at the transaction, we want to just kind of use a common sense approach and ask ourselves, does this transaction make sense? And we look at various things in determining that risk. One of the things that we're going to look at is, what is the judgment amount versus the sale price? Is the property underwater? If somebody's seriously underwater, and even if they redeemed, they wouldn't feel it was worthwhile to keep this property, that may be an indication that there's really not a risk that this owner is going to come back. And that really is the main risk that we're looking at when we're insuring out of these transactions. Generally, it's the foreclosed owner or someone related to the foreclosed owner who may be living in the property, who doesn't want to leave and really may have even defaulted in the action, but once they're being evicted, then they decide that they should speak with an attorney. And that's the risk, that they're going to come back and have some grounds, excuse me, they could come back and have some grounds to vacate the sale or vacate the judgment of foreclosure. Is the property occupied? That probably is the single indication of risk. Is that person willing to get out of the property? Who is that person? Is it the foreclosed owner? If it's actually the foreclosed owner, there's a good chance you don't even want to insure that transaction. If it's someone related to the foreclosed owner, same thing. They may feel that they have a right to live there because their relative owns the property. Are there tenants? What kind of property is it? Is it a commercial property? Is it retail? Are there tenants in there actually paying rent? Is it producing income? These are all things that we want to look at in this common sense approach to whether or not we think someone might challenge the action. What was the method of service? The service is really, it's required under statute in order to obtain jurisdiction. Jurisdiction gives the court authority over the party to the action. And so the purpose of service is to make sure that that person is actually aware that there's a lawsuit going on, so that if they feel they have any defenses, they have an opportunity to come into court and to challenge the action. Even though the service may be legally sufficient, and we see this a lot with corporations, serve the Secretary of State, it may not be designed to actually notify that party of the action. So take a look at the method of service, and all of those things together will help us in determining how risky this transaction actually is. The first thing that gets done in the action is the filing of the notice of pendency. The action is commenced by filing the summons or and complaint or the summons with notice. The complaint has to be filed with the lis pendens unless it's already been filed, and a lis pendens filed without the complaint is defective and void. I don't think we really have too much of a problem with that. I think in these foreclosures we see that everything's all being filed together at the same time. We do have to make sure, because of the requirement that there be a valid lis pendens 20 days prior to the entry to the judgment of foreclosure and sale, that there is a valid lis pendens. So we're going to talk a little bit about whether or not lis pendens is valid depending on the time frames that have been met. Your lis pendens has to, first of all, state the names of the parties to the action, the object of the action, and description of the property. Check your descriptions, and I'm probably going to say that a couple of times throughout this presentation. It's very important to check the descriptions. We have plenty of claims that come in because of description issues, all different variations. But for the most part, when you're examining the title, you want to see that the deed into the foreclosed owner has the same description as the mortgage, so that the foreclosed owner owned a particular piece of property, and that's the property that the foreclosed owner mortgaged. And once the foreclosure action begins, you want to see that same description in the lis pendens and in the complaint. If there's any discrepancy there, you're going to want to stop and take a look at what's going on and figure out, again, how this can be fixed, whether or not there's a risk, and so forth. The owner must be served once the lis pendens is filed. The owner has to be served within 30 days of the filing of the lis pendens. And you'll notice that it's filing within 30 days of the lis pendens. All other defendants must be served within 120 days of the filing of the summons and complaint. Like I said before, they're usually all filed on the same day, so it would be 30 and 120 days from the same date. But in the event that there are different dates, you're going to want to make sure you're aware of that. And it's important to make sure that that has been done, because failure to do so may invalidate the lis pendens, and it may leave room for a defendant to have a meritorious defense. And we'll talk about what might constitute a meritorious defense a little later on. If there is a method of service that requires filing, for instance, a nail and mail service would also require filing proof of service with the court. A failure to file or a delayed filing will not invalidate the lis pendens. So you want to be aware of that. All acts must be complete. So if you're going to serve an owner other than personal service, and you've got a nail and mail situation, you want to make sure that the actual affixing to the door and the mailing has been done within 30 days. Under 1331 of the RPAPL, the lis pendens has to be filed at least 20 days prior to the final judgment being rendered. Now, the courts have held that this is an element of the case and not a jurisdictional issue. And that's important because if the courts don't have jurisdiction, whether it's subject matter jurisdiction or jurisdiction over the person, and this is what we're going to talk about is eventually how they get a jurisdiction over the person. But the fact that they have subject matter jurisdiction, even if the lis pendens is not filed 20 days prior to closing, is actually a good thing. It would preclude entry of the judgment if that lis pendens is not there, but occasionally we see situations where the judgment will be entered anyway. And so the question is, what happens when we see that situation? There's not a lot of case law on this. There's case law on just about everything here, tons and tons of it. This one, the cases that I did find indicated there was a case, Pacific Line v. Lowenberg, and in that instance, the court said that if the failure to file at least 20 days prior can result in the judgment being vacated. So this is just another thing that we want to keep in mind when we're looking at this risk. Is there some reason or something that the owner can grab onto after the fact and say, well, you didn't do this particular thing that was required, and therefore I'm going to make a motion to set aside the sale, vacate the judgment of foreclosure. The court did say that it could result in the judgment being vacated. It also said, the court said it's an element of the case and not jurisdictional, which is a good thing, because it does not affect the validity of the underlying action. So really, worst case in a situation like that, the lender would have to go back, file another lis pendens, and get another judgment, or maybe get an order nunc pro tunc that it was filed. But it's something that you want to be aware of. You want to see that lis pendens effect 20 days prior to the closing. There was another case, I called it an essential prerequisite, later referred to it as a condition precedent. And we'll talk about conditions precedent in a little while as well. The lis pendens is effective for 3 years from the date of filing. In most instances, in other lawsuits, you would need a court order to extend it, but because that lis pendens is required, it's an element of the case. Under CPLR 6516, no court order is required, but you do need to see that it's extended. And there are times when we see that the lis pendens expired, and then we have a gap period in which no lis pendens is effective, and then subsequent a lis pendens is affected or filed, or maybe never refiled. In that instance, any creditors, lienors, deeds, anything that came after that lis pendens was expired is not cut off in the action. And maybe I need to just touch on this quickly, but the lis pendens, when it's in effect, anybody whose interest is recorded subsequent to that is automatically cut off. They don't have to be served. Once that LP expires, they do have to be served. So anyone who appears in the gap, we have a problem there with that interest not being cut off. And generally, what happens is there's a strict foreclosure that would have to be done. In this situation where we have a lis pendens that expired and subsequent recorded interests, the question is, are all of the interests that were cut off while the lis pendens was in effect, do they continue to be cut off? And we do have a case in which a judgment was docketed while the lis pendens was effective. The judgment was entered 3 days after the LP expired, and the creditor was arguing that the lis pendens was a nullity and that that creditor was no longer cut off. The court said that was not the case and that the effect of the notice is not eradicated. So generally, I think that as long as we have interests that came on well while the LP was in effect, they're still cut off. All of this information that I'm giving you is kind of bullet points for you to be aware of. If you have any questions on any of these, for instance, maybe you have a very large judgment that you're concerned about, call and we'll discuss it. We're going to move on to jurisdiction. Jurisdiction, party is not bound by judgments, orders, or decisions of the court unless the court has jurisdiction over that party. And jurisdiction is obtained by serving the defendant by one of the methods in the CPLR. CPLR 308 talks about service on a natural person, and this is generally what we're going to see with these foreclosure actions, owner-occupied types of property. 308 talks about service within the state, If you've got a domiciliary outside the state, that person can also be served in the same manner as service made within the state. The first method is delivery to the person to be served. This is what we call personal service. Personal service is a process server handing the summons and complaint to that person. That's personal service. Any other method is not what we call personal service. There can also be suitable agent discretion, which, be aware, the statutes are very particular, and that's where we, I think, get tripped up, and that's where a lot of the litigation comes from. So suitable agent discretion, it has to be the actual place of business, dwelling place, or usual abode of the person to be served, and mailing. And again, they have to be effected within 20 days of each other. And remember our time frames with the list pendants. Both of those things have to be done within the 30 or the 120 days. I've never seen this done before, but you can appoint someone as your agent designated for service under Rule 318 of the CPLR. I've never seen that, but that's a valid means of service if someone's done it. And then we've got what we call nail and mail, and that's only done when service can't be made personally. And again, we've got both acts, the affixing to the door and the mailing have to be effected within 20 days of each other, and all of that has to be done within the 30 or 120 days. Make sure that you pay attention to the actual place of business, dwelling place, or usual abode, and by any other manner as the court may direct. There is a special summons requirement under 1320. That was one of the statutes that was passed after the 2008 meltdown. There's not a lot of case law on this. We've got some case law that says a failure to do it does not deprive the court of jurisdiction. And you see a lot of that language when you're looking at the cases. So the courts are generally saying, if you're not doing these things, we still have jurisdiction to hear the case, so that's all good. One of the things that I think you need to pay attention to with all of these requirements under the RPAPL, the ones that were passed after 2008, they're all depending on the type of property. So 1320, you'll notice residential property containing not more than 3 units. And this is the language which I printed in your material, the exact language that has to appear in that additional summons. There's also some requirements on serving tenants, but I didn't focus too much on that because when we're insuring out of foreclosure, rights of tenants or persons in possession is an exception in the policy. So whether or not the tenants were served is not necessarily a real problem for us. We need to stop here and provide the first code. The first code is validity. Okay, moving on. There are also some other required notices under 1303. Actions commenced after February 1st, 2007. And this applies to an owner-occupied 1 to 4 family dwelling. Additional notice on colored paper in bold 14-point type has to be delivered with the summons and complaint to the mortgagor. This is a condition precedent to the action. So just keep that in mind, and we're going to talk a little bit later about what this condition precedent is all about. The court says that a failure to serve the 1303 notice need not be raised as an answer in the answer. If the defendant answers and doesn't raise this as a defense, it can still be raised at any time during the action. And that's a little bit different than the affirmative defenses, which we're going to talk about a little bit later on. What I did here is I've given pretty much all of the methods of service, and we don't necessarily need to talk in depth about each and every particular type of method, But you can use this as a checklist when you're insuring and you're examining your foreclosure. If you've got a particular type of entity or a situation and you're not sure whether or not the service was good, you can go back and look at this. So, for instance, infants. You need to serve the parent, guardian, or any person having legal custody. If they're married, serve the adult spouse with whom the infant resides. If the infant's over the age of 14, that infant must also be personally served. Generally, you're not going to see an infant signing a mortgage, but you may have a situation like that if there's a death of a mortgagor and one of the distributees happens to be an infant. We'll talk about the Soldiers and Sailors Relief Act also. You'll see on your affidavits of service very often, you'll see the question whether or not that person is in the military service. Under the New York State military law and federal law, there is a stay of an action typically when someone's in the military, and that enables the court to investigate and determine the whereabouts of that person and whether or not that person has a meritorious defense. Military Law 312 in New York refers specifically to foreclosure actions if the debt is incurred prior to the service. Most of these cases were from 1945, but there was a recent case, and the foreclosing attorney was trying to say that the debt was incurred while the person was in service, and therefore the stay didn't apply. The court said that's not true because there are general protections other than 312 to which, under the federal and New York law, that the defendant would be entitled to. So one of the things you might want to just be aware of is if you find out or you see that somebody is in the military service and there's a default judgment entered, you're going to want to stop for a second and just investigate. Was the court aware of this? Did the court maybe appoint a guardian ad litem and investigate whether or not this person had a meritorious defense? If that wasn't done, then we may have a problem. We need to stop and question whether or not this default judgment is good. When we're looking at service, the United States is very often a defendant. You want to see that they were served in the dual manner, serving the attorney for the district in which the action is brought and sending the summons and complaint, registered or certified mail to the Attorney General in D.C. Service on the state of New York, you serve the Attorney General or an Assistant Attorney General. I don't think we have time to go through this, and I don't think it's necessary, so I'll just make some points on some of these methods of service. Service on an LLC. Generally, we see service on the Secretary of State. Domestic or an authorized foreign limited liability company can be served by serving the Secretary of State, and there's these other different methods of service as well. One thing you want to be aware of, if you've got an unauthorized foreign limited liability company, there has to be service on the Secretary of State and personally delivered outside the state in a manner authorized to serve process in that jurisdiction. So very often we hear from the attorneys that, oh, service on the Secretary of State is good. Not on an unauthorized LLC. So you want to be aware of that. Service on a corporation or governmental subdivision, they've got a list of parties to which the service can be delivered: general agent, cashier, assistant cashier. It has to be one of those parties. If it's not one of those parties, the service is not good. Service on New York, the corporation or council. And again, service on a corporation, Secretary of State on a domestic or authorized. If it's an unauthorized, you again have that dual method, New York Secretary of State and personally delivered to the foreign corporation outside the state. Partnerships we don't see too often, so I've listed there the partnership methods. If you have a partnership, you can refer to that. Limited partnerships and limited liability partnership. A non-domiciliary, there is personal jurisdiction over a non-domiciliary, someone who is not domiciled in the state of New York, who owns, uses, or possesses any real property within the state. And the methods of serving are listed. Any person authorized to make service in New York who is a resident of New York, so that person could travel outside the state to serve. Any person authorized to make service by the laws of the state in which the service is made. So, for instance, it was a Pennsylvania case. In Pennsylvania, the sheriff is the authorized person to serve. The sheriff didn't do it, therefore the service was no good. So you want to be aware of those types of rules. Okay, so we talked about service, and it's important that we see service and know that the court has jurisdiction. If the service is no good, the court doesn't have jurisdiction, and it becomes a problem because that's a defense that someone can raise at any time, whether it's during the action or after the action. And we don't want somebody coming back after we've insured a transaction out of the referee or an REO property saying the whole thing's no good because you didn't have jurisdiction. There are two statutes in the CPLR that a defendant might use to come back and challenge the action, and I think most of us familiar with CPLR 317 and a related statute, CPLR Rule 5015. They're pretty similar, but there are some differences. So under 317, the defendant must show service was other than by personal delivery. Now, we just talked about personal delivery is actually handing the summons and complaint to the defendant. Any other method is not personal delivery. There was case law, which I thought was interesting. Service on the Secretary of State is not personal delivery to a corporation. So a corporation could potentially come back under 317 if there was service only on the Secretary of State. The defendant must show he did not receive actual notice of the process in time to defend, and that defendant must have a meritorious defense. So this is what we're going to talk about. Well, what would constitute a meritorious defense? We'll get to that in a little while. And the motion to vacate the judgment must be made within 1 year from when the defendant obtains knowledge of the entry of the judgment. And that could be by any means. I was looking at a bunch of the different cases on this, and there's tons of them. So, for instance, somebody found out about a judgment entered against him because he was looking at his credit report. So you've got 1 year from when you've attained the knowledge, no more than 5 years from entry of the judgment. We need to stop here, and I will give you the second code. The second code is acknowledgement. Second code is acknowledgement. Okay, and then we've got the related statute 5015. And under that statute, the court may relieve a party from a judgment or order if they have an excusable default. Now, that's the first difference between 317 and 5015. 5015 doesn't require that they show an excusable default. They just have to show that they didn't actually get notice. Excusable default is something like law office failure. I notified my attorney and they lost the stuff and didn't take care of it. Under 5015, it has to be made, the motion has to be made within 1 year after service of a copy of notice of entry. So that actually, that's a measurable time frame for us. We see notice of entry, and then we just take 1 year from that. There are some other methods, newly discovered evidence, fraud, misrepresentation, other misconduct of an adverse party. That actually, I've seen that used as a means of setting aside a judgment of foreclosure. We actually had a claim that I worked on that was set aside on that basis. Lack of jurisdiction to render the judgment or order. And we just went through all of the service issues. So in that instance, you wouldn't even really need a meritorious defense. You just didn't have jurisdiction. So it's very important to make sure that you're looking at those affidavits of service. It's understood under the case law, the statute 5015 doesn't specifically say that they have to have a meritorious defense, but the courts have said that it's pretty much understood that they have to have a meritorious defense. Interestingly, we talked about 317 and the fact that service on the Secretary of State is not personal service. I actually found a Court of Appeals case failure to maintain a current address with the Secretary of State may be grounds to set aside under 317. So you serve the Secretary of State, the defendant didn't keep their address current, they never got actual notice. They can argue that they didn't get actual notice and set aside a judgment of foreclosure and sale. What constitutes a meritorious defense? We're going to talk about that in a little while with these conditions precedent and some affirmative defenses. Okay. I think that's all when might 317 be omitted? Generally, and we're going back to our initial discussion about risk. Generally, our risk analysis, we're going to look at whether or not the property is vacant. If you've got a potential 317 exception, but the owner has voluntarily vacated the property or been evicted, then we can omit it. I've seen some exceptions that say this exception will be omitted upon conveyance to a bona fide purchase of a value. I don't know why that would be the basis for omitting it. The defendant is not going to not raise a defense or come back in motion to set aside the judgment and sale because it was conveyed to a BFP. I think that you need to verify that the property is vacant regardless of whether or not the conveyance is to a BFP. That, I don't see that as the basis for omitting that 317 exception. When the defendant appears by answering, filing a notice of appearance, and making a motion to extend the time to answer, that's equivalent to personal service. So when we see in these actions that the defendants have answered, that's good. We like that. We know that they have the court has jurisdiction. And then that's Rule 306 in the CPLR, affidavit of service has to be filed with the court. And you'll see on page 7 the proof of service. What's supposed to be included in that affidavit of service? Like, for instance, in nail and mail, they need to actually state how many times they attempted personal service. The thing that we like about these affidavits of service is that the courts have been very clear that the affidavit of service is prima facie evidence of service. And when people come back and try to argue that there's no jurisdiction because I never got service, you can't allege that you didn't get service. They actually have to provide evidence that they were somewhere else other than where the process service said they were served. So we can pretty much rely on these affidavits of service in determining whether or not there is jurisdiction. Moving on to the parties to the action, the holder of the note and mortgage is the proper plaintiff. That's very clear. That is the party that has standing to foreclose this mortgage. If there are multiple mortgagees and for some reason not all of them are joining as plaintiffs, then those plaintiffs have to join the other as a defendant. That maybe you'd see with a private mortgage held by a number of people. When the mortgage is assigned, substitution is not necessary. So sometimes you'll see that the action is started in the name of one plaintiff, and during the course of the action it's assigned, but there's been no substitution of parties. That's okay. It's not required. But prior to the sale, the assignee should provide the referee with the assignment. Necessary parties. Who has to be a party to this action? Every person having an estate or interest in possession or otherwise in the property, tenant and fee for life, et cetera, et cetera. You can look at the material on page 8. Pretty much anybody who's got a record interest on the deed, life tenants, lessees, any type of interest, they all have to be joined as parties to this action in order to cut off this right. The statutes talk about courtesy and dower. That's been abolished. So if you've got a married person in title, you don't have to join that spouse unless the spouse is also in title. Any person having any lien or encumbrance on the property which the plaintiff claims is subject and subordinate to the lien. Obviously, if you've got liens that are prior to the foreclosed mortgage, that's something that you're probably going to have to investigate and obtain clearance for. Representative parties, the trustee of a trust, you can serve the trustee of a trust. That will cut off all of the persons interested in the trust, beneficiaries, etc. The executor of a will, service on any one of those duly qualified executors is sufficient service. I think that if the will specifically devises the property to a particular person, you probably want to serve that devotee also, because at that point the title vests in the devotee once the will is probated. An administrator is not a representative party, so if you've got a deceased borrower and there's been an administration, you need to serve all of the heirs, not the administrator. If there's no administration and there's an allegation that the persons named are all of the heirs, then we're going to have to investigate the heirship. And I think the foreclosing attorneys have methods of doing this. They have these different search mechanisms that they can determine who the heirs might be. Okay, the required notices under 1302. The complaint has to contain an affirmative allegation that the plaintiff is the owner and holder of the subject note and mortgage. Filing, they must file with the superintendent under 1306 as a condition precedent, again, that word that they did that 90-day mailing. Pre-foreclosure notices under 1304. That's the 90-day notice that has to go to the borrower. These are all conditions precedent to the action. And just be aware of under what circumstances these notices have to be sent. Again, what type of property requires it? So owner-occupied property. A home loan under 1304, the borrower was a natural person. Debt was incurred primarily for personal, family, or household purposes. And we've got a 1 to 4 family dwelling used or intended to be used as a primary residence. Compliance with 1302, 3, 4, and 6 are conditions precedent. What is a condition precedent? In this case that I found, which was not related to real property, a condition precedent is different than an affirmative defense. Affirmative defense, such as a lack of standing, if it's not raised, it's waived. The condition precedent is not waived. It can be raised at any time during the action. And it can also be raised as a meritorious defense if you're trying to vacate the judgment under 317. So you need to be aware of that. When we're dealing with our 317, we want to make sure that we've got jurisdiction. We want to make sure that all these conditions precedent have been satisfied and there's no affirmative defenses that might be raised after the fact. By statute, plaintiffs now have to file the certificate of merit, but they're essentially saying that they have standing. Standing doesn't seem to be too much of a problem now. I think the foreclosing lenders all get it. They got too many judgments set aside because of a failure to have standing. So I don't see that as too much of a problem, but we need to be aware of these conditions precedent. There's actually a lot of cases out there, but the courts have talked about these conditions precedent as almost being a super defense. That was the language that was contained in one of the cases that I saw. It can be raised at any time. You want to make sure that when you're dealing with the state that they're pleading with particularity. So, like for instance, with these ECBs, they can attach a copy of all the ECBs, and there's certain information that they have to provide. You want to be aware that possible federal estate taxes or possible New York estate taxes, that's not a good pleading. You really need to identify what the lien is if you're going to serve and make a U.S. or the state a party. So possible estate taxes, if somebody's deceased and you're looking at a surrogate's proceeding, look at the petition. If the petition alleges, one primary residence, there's probably no estate taxes anyway. And if you don't plead with particularity, you're not going to cut off that defendant anyway. So try to avoid just possible estate taxes. If we think there's an issue there, we'll address it after the fact. If a city is made a defendant, there's a method of also pleading, and you need to make sure, we're looking at page 11 in the material, and you can refer back to this for the particulars if you're looking at this situation. I just want you to be aware of all these rules. Moving on to the judgment of foreclosure and sale. The section was amended in 2016 to state that the sale must occur within 90 days of judgment. So if your sale is not taking place within 90 days of the judgment, you might have to go back and get the judgment renewed or an extension. Very important here, the referee lacks authority to vary the terms of the sale from the terms of the judgment. Unauthorized variations are void, and the court has discretion to set aside the sale. You want to look at your judgment of foreclosure. You want to see what your judgment of foreclosure says, and you want to look at the terms of sale. And you want to look at the referee's report of sale after the fact and make sure that everything was done in compliance with the judgment. The borrower's right to redeem is extinguished by the sale regardless of when the deed is delivered. So if we see sometimes borrowers will file a bankruptcy petition the day before the sale, that's a problem for us because the sale can't take place. If, however, the sale occurred, the hammer dropped, and subsequent to that, the borrower filed a bankruptcy petition, even though the deed was not yet delivered, that's okay. And the buyer takes subject to the terms of sale. So you want to look at what the terms of sale say, and sometimes this is an issue that arises when somebody's negotiating or arguing that they want certain exceptions removed from the property, from the policy. If you went to the auction and you bid and you took subject to the terms of sale, or say subject to 317 and 5015, and you're now demanding that it be removed from the policy, not necessarily. So be aware of all this. Look at your judgment, look at your terms of sale. We've got the rule under 3215, a natural person, if there's a default judgment, they're required to get at least 20 days before entry of judgment an additional copy of the summons. We want to see that because when we were talking about these conditions precedent, the court said over and over and over again that it doesn't deprive the court of jurisdiction. In a case that I found, the court said a failure to comply with 3215 does deprive the court of jurisdiction. So that's something that you definitely want to see has occurred. And that would be in a residential mortgage foreclosure action, which is owner-occupied. Conduct of the sale, parties who appear or answer entitled to notice. A defaulting borrower is not entitled to notice of sale. This has come up a couple of times where agents call and they say, the referee appointed in the judgment was Mr. Smith, and Ms. Jones showed up to conduct the sale. That is a problem. The referee who's appointed is the one who has to conduct the sale. Under RPAPL 231, the judgment, property sold pursuant to a judgment has to be auctioned off. And we've got these rules on publication. The notice of the sale has to be published. Notice that we're talking about whether or not property is wholly or partly within a city, then there are different rules as opposed to whether or not it is not. If they're within the city of New York, we have rules for that as well. And then posting. Publication talks about whether something is wholly or partly within a city. Posting, if the property is wholly outside a city or an incorporated village, then posting is required. The time of publication, you want to count the days, make sure that the publication took place within the time frames. And if we've got an irregularity with the conduct of the sale, there is a one-year statute of limitations for failure to comply with the provisions. So if you're looking at that and the time frame has elapsed, we're probably okay because we've got that one-year statute. The referee's report of sale has to be filed within 30 days of completing the sale. The case law that I saw on that said failure to file is usually treated as a mere irregularity. Title is conveyed, although no report is filed. So that's pretty much it. Those are the bullet points. It was a very short presentation on something that is really a massive body of law. But if you have any questions, please feel free. I hope that this gave you some things to think about. And while you're examining your foreclosure actions, please feel free to call counsel at any time to discuss any of these transactions. Your
Judy?
last code, yes.
No, Judy, we actually have a couple of minutes and we have some questions, so if you want, we can just answer a couple of them now because we do have some time. Okay, so one of the questions, and then after the questions, we'll announce the last code. So the first question was, how do we verify that the property is vacant? Whose word would we want to take?
Well, I mean, yeah, that is a good question. I mean, if it's an REO property, these REO properties, they have managers managing these properties, and they ought to be able to tell us whether or not they've evicted, there's been an eviction, or whether or not the person voluntarily vacated. Sometimes they do this cash for keys. A lot of times the buyer of the property, some of these buyers are pretty sophisticated people, and they'll maybe go to the property and try, if the property is vacant, to talk to them and see if they can make a deal with them to get out. I think the buyer, and again, it all depends on credibility. How well do you know this particular customer of yours? Is this somebody who represents a lot of investors, or is this an investor that you deal with all the time? Can you trust this person? You know, if this is a deal that somebody just brought to you, like, oh, I want to do business and here's my first deal, and it looks like it's a mess, I would be less inclined to believe what they're saying. What type of property is it? Is it a multifamily? You know, because sometimes you've got tenants in there and you don't know who the tenants are. So it could be a lot of different people. The seller usually won't give you anything because the seller is usually the referee or the foreclosing lender, unless it's an REO property. So for the most part, I think we need to look at the buyer and determine the buyer's credibility and how well you know that buyer.
Okay, here's another one. Would you consider a subordinate mortgagee to be cut off if service is on MERS as nominee for the lender? MERS is served by CT Corporation in Albany, and there was no appearance by MERS or the lender. Please comment on serving MERS instead of the lender, especially since the lender may have changed in the MERS registry without any recorded notice.
Right. Well, that's the problem that we were talking about with the service on the Secretary of State, or in this instance, their designated agent. If you're going to appoint MERS as your nominee, then you ought to be able to cut them off by serving MERS. But the question is, even though the service was technically good, if we believe that that lender did not actually have notice and may have actually decided to appear in the action if they had notice, then we're not going to necessarily agree to insure. So again, this is all the risk that I'm talking about. What I tried to present here was some, rather than say rules, guidelines, bullet points of things to be aware of and things to think about. But it all goes back to our common sense analysis of the risk. So how comfortable do we feel that that lender is not going to come back and set aside the action?
Okay, we'll do one more and then we'll are all the liens prior to the filing of the Liz pendants, including mortgages, open?
Yes. Just by the recording statutes, if you've got interests in the real property recorded prior to the mortgage, then they are prior to the mortgage, at least according to what we see on the record, and they can't be cut off merely by filing a list. Well, they can't be cut off even if they're served, unless there's an allegation that for some reason they're subordinate. So anything prior to the mortgage is not cut off, and I think that's the question, and you'd need to investigate further.
Yes.
It's not the list pendants. It's not the list. It's not the list pendants. It's prior to the mortgage. Anything after the mortgage is going to be served.
Okay. All right, then the final program code is recording. Program code number 3 is recording. We had a bunch of other questions, so we will make sure that Judy gets them, and then we'll respond to the questioner, or maybe we'll send a memo to everyone so that they can see the Q&A. So thank you, Judy. Thanks to everyone for joining us this morning. Just a reminder that if you were logged into the webinar, you will be receiving within the next 10 minutes or so an email with the links to the attendance and evaluation forms. Our next webinar is scheduled for Tuesday, May 22nd. Paul Malon, Fidelity Senior Agency Counsel, will be presenting the significance of land surveys to the title insurance process. Thanks, everyone, and have a great day.